A British judge has finally ruled on whether Australian journalist and WikiLeaks founder Julian Assange will be extradited to the United States to face espionage and computer hacking charges. I was at the extradition hearing, as well as the verdict and the bail hearing, in what many have called the trial of the century. I'm Richard Medhurst, and you're watching the Communiqué. In September and October of 2020, the extradition hearing of journalist and WikiLeaks founder Julian Assange took place at the Old Bailey in London. The United States wants to extradite Julian Assange to face a trial over allegations that he violated the Espionage Act of 1917 and the Computer Fraud and Abuse Act. Julian Assange published documents like the Iraq war logs, the Afghan war diaries, and State Department cables showing various atrocities and war crimes that the United States had committed overseas. The United States is threatening him with up to 175 years for the publication of these documents. Various witnesses testified on Assange's behalf during the hearing, including human rights lawyers, computer scientists, medical experts, journalists, and media partners of WikiLeaks. They argued that the publications by WikiLeaks exposed very serious government crimes and wrongdoing and were essential for the public interest. They argued that sending Assange to jail would effectively criminalize journalism. And not only that, but the fact that the United States would be able to prosecute a journalist in another country of a different nationality and the dangerous precedent that this sets for press freedoms. Finally, last week, we received a decision from Judge Medhurst. She ruled against extradition. Many were jubilant about this at first, but it is very important to note why and how she came to this ruling. Judge Medhurst blocked the extradition of Julian Assange only on the grounds of his health. She accepted that he suffers from depression and Asperger's and agreed with the medical experts who testified at the hearing. She agreed that if he were to be extradited, there is a high probability that Julian Assange would be placed in a federal supermaximum prison like ADX Colorado, and under very brutal and harsh special administrative measures, which are designed to completely limit physical contact between prisoners and keep them in complete isolation. Given these circumstances, she accepted that there is a high risk Julian Assange would commit suicide if sent to the United States. Now, on the other hand, before Judge Medhurst came to this conclusion, she spent a fair amount of time going through this case and agreeing with almost every allegation put forward by the United States prosecution. She agreed with basically everything in the indictment and did not challenge the political nature of these charges. According to Medhurst, she found that the U.S. prosecutors had acted in good faith, that Donald Trump did not harbor any particular contempt for Assange, and that essentially the entire case was not political. This is, of course, absurd because we've heard not only Trump, but several other officials from his administration, like the former Attorney General Jeff Sessions or U.S. Secretary of State Mike Pompeo, openly talk about prosecuting Assange. Not to mention that the very nature of WikiLeaks publications is evidence of war crimes and government secrets, which makes this political by nature. Judge Medhurst went on to accept the allegation that Julian Assange supposedly tried to crack a password with Chelsea Manning. She said that Assange's activities went beyond those of a journalist. Again, this is very dangerous as it implies that national security journalism, investigative journalism, and standard journalistic practices like protecting one's source are criminal activities in her eyes. The judge also parroted the claim by the prosecution that Julian Assange and WikiLeaks releases endangered the lives of informants, which is again completely false, and even contradicts the Department of Defense's own findings that no one has ever been harmed by the publications of WikiLeaks. What is also astonishing is that Judge Medhurst refused to even take into account the fact that the United States intelligence services hired a Spanish company named UC Global to spy on Assange while he was inside the Ecuadorian embassy. She said that this was because the trial against the company's founder, David Morales, was still ongoing in Spain, and she didn't want to make a decision without having all of the evidence. Okay, well, how can she say then that this case is not political if the Spanish court case has not been concluded? In her ruling, Judge Medhurst also said that she thinks Julian Assange would be afforded constitutional protections and receive a fair trial. She did not think, for example, that his right to a fair trial under Article 6 of the European Convention of Human Rights would be violated. But again, how can she say this when we know that the United States is going after Assange with charges of espionage, which is a political crime, and when we know that the United States spied on Julian Assange and his conversations with his lawyers, not to mention that when Julian Assange was arrested and dragged out of the embassy in April of 2019, his personal effects were taken and passed along to the United States, meaning that the United States could use all of this tainted evidence against him in a trial, which by definition would make it unfair. Now, we also know that a trial in the United States would most likely take place at the Alexandria Division of the Eastern District of Virginia. This is the jurisdiction of the so-called espionage court, which is where the indictments were issued against Julian Assange and others like Snowden, Manning, McKinnon, and Lori Love. The jury pool would be made up mostly of people who work for or who have family in the intelligence community, people who hate Julian Assange. Shockingly enough, Judge Bretzer didn't seem to think that this is a problem and took the word of federal prosecutor AUSA Kronberg that the jury would be impartial. All in all, this ruling by Judge Bretzer makes one thing very clear. The United Kingdom is prepared to uphold the political charges put forward by the United States, which leaves the door wide open for future journalists to be prosecuted and persecuted by the US. According to her judgment, if Assange was in perfect health, then she would essentially have extradited him, which is very frightening. Now, even though the judge ruled in Assange's favor, he was not free to go just yet. The prosecution, on behalf of the US, said that they would appeal her decision not to extradite. And so Bretzer asked Assange's team if they would like to make a bail application for him. While his defense did say that they had the strongest grounds for bail to be granted, they decided to make the application 2 days later, on January 6th. So on January 6th, we had the bail hearing. I was again granted access to the court via remote video, and I was able to cover it. This took place not at the Old Bailey, like the extradition hearing and the verdict, but instead at Westminster Magistrates Court, also in London. It is very important to remember that since April 2019, Julian Assange has been held at HMP Belmarsh, which is a Category A maximum security men's prison on the outskirts of London. He was given the maximum sentence of 50 weeks for allegedly absconding bail in 2012, which was really just a way to punish him and give the United States ample time to prepare an indictment against him. So even after completing his sentence, he was still kept there and has been unable to leave. I visited the outside of this prison in October after covering the extradition hearing. It is truly a grim place where the worst of criminals are sent. The fact that Julian Assange was sent there at all speaks volumes as to the political nature of his persecution. The fact the United Kingdom is putting a man, a journalist, in a maximum security prison with terrorists and murderers is astonishing. Now, when the bail hearing took place on January 6th, the prosecution argued that Assange was a flight risk because he had previously failed to surrender himself to the courts after he sought refuge and political asylum in the Ecuadorian embassy in 2012. They also cited the potential of other nations willing to offer him asylum and referred to the latest statement of the Mexican president, Andrés Obrador. The defense countered these arguments with the following. They said that since Judge Bretzer has ruled against extradition and ruled in Assange's favor just 2 days before, this meant clearly that he had no reason to abscond or jump bail because he now had the full protection of the rule of law. The fact that the judge ruled against extradition meant that he has no reason to go anywhere. The defense also pointed to the fact that finally, Assange being able to reunite with his family, with his partner and his children would anchor him to them. And again, this would give him no reason to go anywhere. Now, regarding the claim that Assange could be given asylum by another nation or just walk into another embassy, as the prosecution claimed, the defense pointed out that these reports of Mexico offering Assange asylum had been widely misquoted. Assange was offered asylum by President Obrador, but only after the legal proceedings were to be concluded and by going through the official channels. The reason is that even if Julian Assange is ultimately not extradited, he does remain safe in the UK, but that doesn't mean that he will be safe elsewhere. For example, if he travels to another country or jurisdiction with which the United States has an extradition treaty, he could still be extradited from there. Hence why Mexico offered him this asylum, and hence why it is safer for Assange to remain in the United Kingdom. A very valid point for him not to abscond. Other reassurances were also given by the defense to the judge, including the fact that Assange would remain under house arrest with a GPS tag to monitor his location in real time, and that he would be living with his partner Stella Morris and their 2 children. Despite all these reassurances and the fact that the judge ruled against extraditing Assange, she decided not to grant him bail. As I pointed out before, even people like the Al-Qaeda cleric Abu Qatada were let out on house arrest from the very same prison from Belmarsh. The Chilean dictator Pinochet was also allowed to live comfortably under house arrest in London. The fact that Assange is a free man, guilty of no crime, and still has to go back to jail, to a maximum security prison, speaks volumes and shows that this is a purely political affair. We'll be right back after this short break. One of the more outspoken voices who visited Assange in Belmarsh with a team of doctors and said that Assange showed all symptoms typical for prolonged exposure to psychological torture is Nils Melzer. He is a professor of international law and also the United Nations Special Rapporteur on Torture. He joins me now. Thanks for coming on the show, Professor. It's good to have you.
Thank you for having me.
Professor, can I get your initial reaction on Julian Assange's bail being denied by Judge Baretzer? What are your thoughts on that?
Well, unfortunately, I have to say I'm not surprised. I guess Monday's decision to refuse his extradition was initially surprising. I think on second thought, it is not even that is so surprising because it could also be quite a malicious move to reduce, let's say, the issues that can be discussed on appeal to a medical issue, and then allow the U.S. basically to just make diplomatic assurances as to the treatment that they will give to Julian Assange in the U.S., and thereby can circumvent a full discussion of all the issues that have been raised in court by the defense. But the short answer really is that Julian Assange should never have been in Belmarsh from the beginning. He has been arrested. If the UK insists on putting him in prison for a bail violation 7 years earlier, which is completely exceptional. It never happens in the UK that you go to prison for a bail violation unless you committed a crime during that bail violation. But bail violation itself is an administrative offense. So no one goes to a high security prison. And, we have to understand that high security prison detention is something extremely expensive. You only do that because to people that pose an imminent security threat. And Julian Assange obviously is a non-violent, publisher. He has been put there not because he is a security threat to anyone in terms of violence or criminality, but because he was put there to be silenced. Because obviously in a high security prison, you have a very strict security regime. You can limit visits, you can limit communication, you can limit access to, internet, to working tools and so on. And that's exactly what was the intention. So to keep him there from the beginning has been unnecessary. It has been disproportionate. Once he had served his sentence, he was, since September 2019, he's there only for preventative purposes to ensure his availability for the extradition proceeding. Others have been held in house arrest for these types of things. Even former Chilean dictator Pinochet was held in 1.5 years in house arrest in the villa, received visits by the former prime minister. Well, could you imagine Julian Assange being held in a luxurious villa and receiving visits from Tony Blair? I don't think so. But I'm making this caricature not because it's funny, but because it illustrates how unbalanced this prosecution has been, and that this has never been about the law. It's always been about politics and about silencing him and not about prosecuting him for anything he's done.
While it's good she ruled against extradition on health grounds at the very least, she agreed with everything else put forward by the U.S. prosecution. Could you elaborate on that for us?
First of all, yes, obviously, I agree that he cannot be extradited to the U.S. because he would be inhumanely treated there. And that's something that I said already on the 5th of April, 2019. He was still in the Ecuadorian embassy. And I called on Ecuador not to expel him because of precisely that risk of ill treatment and, torture in detention conditions in the U.S. Supermax conditions are recognized not just by me, but by my predecessors, by Amnesty International, basically everybody who's dealing with human rights, acknowledges that Supermax detention conditions, especially under the so-called special administrative measures, amount to torture and other ill treatment, which is absolutely prohibited under the Convention Against Torture. So you can't extradite a person towards a country that practices these types of detention conditions. And the U.S. has been quite, open about the fact that that's precisely what they would be doing to him when extradited. So on that account, yes, her decision actually confirms my assessment as to the risks of torture and ill treatment in the U.S. And certainly that is something I can only welcome. However, but then technically what happens is obviously that all the other issues, the whole rationale that underlies the U.S. prosecution has been confirmed point by point in a quite outrageous way, really.
Professor, you visited Julian Assange in Belmarsh prison with a team of doctors. You saw the condition that he's in. You said he showed signs of prolonged psychological torture. You saw him there, so how can she justify sending him back if the entire pillar of her judgment from Monday not to extradite him is based and rooted in mental health?
The day I visited him, the 9th of May, 2 days before, a razor blade had been found in his cell. And he actually talked to me about this when I visited him. And he also made very clear that he would not be extradited alive. So he has this determination. I think I would agree that probably his risk of suicide is much higher in the US than it is in the UK, because in the UK he still has hope that he might not be extradited, and after that he would be released. And once he's in the US, he knows that he will never get out of prison again. And so it's a different kind of prospect. So I think that objectively certainly is a difference. But what has to be very clearly stated, there is no justification for him to be in a high security prison. Even if, there's no justification to prosecute him, to extradite him in the first place.
Are you holding out much hope in regards to the Biden administration? Because yesterday we heard from the outgoing prosecutor of the Eastern District Court of Virginia that this Assange case has consumed a lot of time and resources. What did you make of that report?
Yeah, I think that we should give the incoming president the benefit of the doubt. Although he has been part of the Obama administration, and unfortunately, President Obama has been instrumental in destroying the rule of law and the credibility of the U.S. in terms of human rights law. We're talking about the drone killings that he has basically institutionalized, his refusal to prosecute torture by the CIA, although we have a 7,000-page report confirming all of these things. He's being hailed somehow as a human rights champion, and he receives the Nobel Peace Prize on credit. But then, what the reality of this is much more worrying. So obviously, we all know that he conducted a veritable war against whistleblowers. And yes, he did not decide to prosecute Assange, but then also he never gave him any assurances that he would not be prosecuted, which is why for 7 years he stayed in that embassy. And the Democrats were very happy having him blocked in the embassy and incapacitated in this way. And Biden has been part of that administration. So it's open to see what he will do once he is president. It's possible that he will decide that he will not prosecute him under the Espionage Act because he doesn't want to have a confrontation with the New York Times and so on. But then he will just expand the computer fraud charges. I mean, that's a possible scenario, but we have to admit, at the moment, it's just speculation. They could be very comfortable releasing Assange based on medical grounds and keeping that kind of threat scenario pending above his head for the rest of his life, that, if ever he should go back to WikiLeaks and taking up his profession again and challenge the power of the US again, they will just start this whole proceeding all over again.
Going forward, how hopeful are you that the decision not to extradite Assange will be upheld? And how hopeful are you that the decision to deny him bail will be overturned?
It's very difficult to say. I think it really, if we've learned anything of the last 10 years of his persecution, is that this has never been about the law. It's not been about the law in Sweden. It's never been about protecting women, against sexual violence, which is a very important issue. But this has not been the intention of the Swedish authorities. If anything, these Swedish authorities have destroyed these women's lives as well. They never cared about that. So this has been a political persecution in Sweden already. It was a political persecution afterwards in the UK while he was in the embassy, where the UK always pushed Sweden never to drop the charges, even when Sweden wanted to drop the charges. The British, for all, they were not even involved. These women were not British. It didn't happen in Britain. Why would they care? Because they had a political motivation. Britain initially even wanted to storm the Ecuadorian embassy. Remember, William Hague actually threatened to storm the Ecuadorian embassy when he sought asylum there. And that's absolutely unprecedented. You don't do that because of someone who is wanted in Sweden. And I underline, he's never been charged in Sweden. He was wanted for questioning. You don't storm an embassy of another country because there's someone there who is wanted for questioning in a different country. So where there is smoke, there is fire. And there's been a lot of smoke in this case. And so there is a fire that is very, very important. It was always about political motivations to silence Assange. This is not about the law. Even Monday's decision is not about the law. We don't know exactly what has been negotiated, behind the curtains, but there is a political motivation behind this. And unfortunately, what happens at appeal will be also governed by political motivations. Unfortunately, I think that's just a reality. And the only remedy against that is that the public becomes aware of what's going on and demands accountability. And demands that the law is actually being upheld.
The indictment brought forward by the U.S. effectively criminalizes investigative journalism and national security journalism. It sends a message to journalists everywhere that if they expose the United States and its NATO allies for their war crimes, then you're not safe. The fact that the UK is allowing its soil and its courts to be used by the US to carry out political persecutions is an abomination. The judge is fully aware that he is suffering from depression as a result of years of a political witch hunt. So to send him back there is irresponsible and indicative that she is more than willing to serve the interests of the United States rather than those of a fair justice and a moral justice system. Julian Assange is not a convict. He's not guilty of a crime. He's not serving a sentence. He should not be in jail. Never mind in a maximum security prison. This is cruel, this is inhumane, and it goes against everything the United Kingdom, the United States proclaim to uphold. There can be no freedom of press, nor accountability of government so long as Julian Assange and others like him, such as Edward Snowden and Chelsea Manning, are persecuted for bringing to light crimes committed by their governments. The United States will appeal the decision by Judge Bretzer and challenge it in the High Court. Subsequently, Julian Assange's defense team will also be appealing the decision of the bail hearing and attempt to overturn this as well in the High Court. Until then, Julian Assange remains locked in Belmarsh prison. And what comes next remains to be seen. Thanks for tuning in. I'm Richard Medhurst, and this is the Communiqué.